I'm testifying here today on the behalf of the National Roofing Contractors Association, but I'm also testifying here today on behalf of the Essential Worker Immigration Coalition, which is a coalition of businesses spanning the spectrum of American industry. I serve as a co-chair of that coalition as well, and I would like to speak today about the intersection of the small business community and our nation's current immigration laws and how those might be changed in the coming year if we see successful immigration reform in this Congress. My comments will break down broadly into four areas. First, the demographic challenges we face. Secondly, our current system, focusing specifically on two initiatives by the Department of Homeland Security's Immigration and Customs Enforcement Division. Then I would like to talk about concerns with certain proposals that are currently under consideration. And finally, our belief as to what a workable immigration system would look like, particularly from the small business community's perspective. I understand that I have time constraints, so I'll try to be brief and touch just broadly on these topics. NRCA and EWICS members come to the table, just like every other business, frankly, in this country, from the to the immigration debate from the perspective of meeting our workforce needs. Ben touched upon what we're facing from the demographic standpoint. I'd like to focus on two industries in particular. They're two of the largest private sector employers in our economy. That is the construction industry and the roofing industry, and the restaurant industry. Regarding the construction industry, this is what we're seeing in the industry today. There was data released by the Pew Hispanic Center on March 7th of this year. They found that construction employed 2.9 million Hispanic workers in 2006. Total employment for the construction industry is 11.8, so fully 1/4 of every employee in the construction industry is of Latino or Hispanic origin. 2.2 million of the Hispanics in the industry were foreign-born. And a staggering number of those were recent arrivals, meaning that they came from they've arrived in the country since the year 2000. That's important to bear in mind because you need to keep in mind that this country only allows 5,000 green cards per year of essential worker visas, and that translates into a waiting list of about 10 to 12 years. Because, and frankly, the number would be a lot higher if employers decided to take advantage of that program. Then we also have the H-2B program. That's a seasonal visa, and that only allows for 66,000 a year. It's capped at that level. In 2006, the construction industry employed a total of 559,000 new workers. And of that number, 372,000 were of Latino origin. That translates into 66.5% of all new hires in the industry last year were of Latino origin. About 60% of the increase in industry employment, or 335,000, were foreign-born Hispanics. And 255,000 of the total increase, or 45%, were arrived in the country since the year 2000. In total, nearly 1/3 of all recently arrived foreign-born Hispanics worked in the construction industry in 2006. So clearly our industry is a big draw. Regarding the restaurant industry, we're seeing that the restaurant industry is going to need an additional 15% of its workforce. They currently employ 13 million immigrants, foreign-born. They currently employ 13 million workers in total, but we know that they're going to need an additional 2 million over the next 10 years. I see I'm running a little short on time, so I'm going to skip over to what we're facing in the current system from the small business perspective. There are two initiatives underway. One is what's called a Social Security no-match proposal that's been issued by the Department of Homeland Security's Immigration and Customs Enforcement Division, came out last August. They are signaling that they would like to prosecute employers for continuing to employ workers that have been the subject of a Social Security no-match letter. The second issue is this ramped-up enforcement of immigration and customs enforcement that we're seeing across the nation. I want to be very clear. Our members are supportive of adhering to immigration laws. They do their best to adhere to them. But the system is broken. It's difficult. It's unwieldy to manage. And what they're finding is that they're grappling with a system where the rules are unclear. A good example is this. If somebody comes through your front door and they give you a form of identification, it might be one of 27 different forms because currently that's what the law says that an employer has to accept. If the person looks like they may not be of a native-born worker, you are not allowed to challenge them. And that's probably a good thing. I think that would run afoul of what this country is about. But it would violate employment discrimination laws. Under the proposal that we're considering now, an employer would be held liable in the future even though they would be prevented from asking these types of questions due to anti-discrimination statutes that we have on the books. And so you would have a drastic increase of what we see going on in the workplace in terms of raids by ICE and them coming through the front door, but you're not allowed to really question and investigate whether or not your workforce is legal. I see my time is up, and I'll just be happy to answer any questions.
Sure.